Also, why the inconsistent disclosures? Why is it that between different countries, they get different amounts of information? It's important to point out, Guatemala is not unique here. Guatemala is the third country on this precise issue that's bringing this kind of challenge. With all that Dr. Alexandrov knew and all that was happening, he chose to say nothing, and that is deeply concerning. Let's turn to the next slide, slide 7. So I'm not going to really get into the background of the grounds for annulment. You all have been on many annulment committees, so you are familiar with this. We're going to be talking about Article 52. Next slide, slide 8. These are just some, some sort of emblematic cases that help us to understand how to look at Article 52. I cite them just to kind of give us a bit of guidance as we go into really the text. And the parties have fully discussed this in their briefs, which you have, of course, read. Slide 9, please. Let's begin with Article 52(1)(a). And the word that we're going to focus on is constituted. Constituted doesn't have a temporal limitation. Now we're talking about the ordinary meaning, right? So there's the 3 different ways that we look at it under the Vienna Convention. Under the ordinary meaning, there's no temporal limitation. It means to give legal form. It is a state of being that continues as long as those elements are present. For example, if we are going to constitute a committee because it has quorum, quorum doesn't end as soon as the meeting starts. The committee is constituted because it has quorum as long as the individuals are there, right? If you're going to constitute a system of courts, they don't stop existing after the legislation is signed. They continue to exist as long as the legislation exists that constituted them. Something important that Guatemala does, and that was done in ICSID, but not in other cases, is looking at what constitute means in the other official languages. So if you look at it in Spanish or French, there's a reference to reunirse, to bring together, congregarse, to congregate. It is not the notion of a one-time thing, but rather something that continues into the future. Constitute is a verb, and all of these words that I've just mentioned to you are not words about process. Process is described using different words. This is a verb about what it means to be, to exist and have legal form, for that form to continue. There's nothing vague or ambiguous about these words, and honestly, they're really, and from what we have read, isn't a lot of dispute as to what these words mean. Now let's go to the next slide, slide 10. I've referenced ICSID. We're going to reference it a lot, and the reason that we reference it here is not just because it's a case that came out with the correct result, but because it is more persuasive by virtue of the analysis that is done and the way that committee looked at the words that we are tasked with analyzing, and also the facts from that case. ICSID we share with ICSID the definition of, or the ordinary meaning of, constituted, and the other verbs that come before it really don't change the meaning. So it's best just to look at the word, interpret that word, and apply it to our case. Next slide, please. Slide 11. So this is where the real distinction comes. Instead of looking at constituted, TECO wants to take us to procedures. Now, procedures, that word isn't in 52(1)(a), right? That's the word that's imported through the word properly. Properly, as we know, is an adjective in this context. Actually, probably be an adverb. But the point is that properly isn't a noun, right? Process and procedure are nouns. And just because you have a word proper that maybe has the first sort of 3 letters of procedure or process, it doesn't mean that we necessarily import it. On this point, Azurix and OIEG, two cases that are frequently cited by TECO, they really try to go and follow this route. And in both of those cases, they are decidedly not only unhelpful, but unconvincing. Azurix especially, because Azurix, this is one of the earlier decisions. And I think it's important just to reflect on the fact that we're still in a pretty young practice, right? I mean, the modern practice of international arbitration is pretty young. And so some of the earlier decisions, it's nobody's fault. They're still kind of figuring it out. And there constituted was analyzed in the context of a challenge as to the text of the decision on challenge, not as to the underlying facts, right? So it's difficult to really draw much from Azurix when Azurix was so limited to the kind of challenge that was presented. OIEG, it really hasn't been widely followed. It only looks at the English version of the convention. It doesn't use the other two languages that kind of help to inform what the word constituted means. And the commentators cited by TECO, they don't really engage with this ordinary meaning. They kind of pass over it. And whenever we have an ordinary meaning, and it's there as the verb to really drive that specific piece of Article 52 1A. And some of those commentators, I mean, really what they are doing is they're talking about what they want to see in the convention, but that's not what we're doing. We look at what the words are, not the way we kind of would like for those words to be read in other contexts, or just what we want the convention to say that it doesn't actually say. Slide 12. So let's go from ordinary meaning to context. And context, this is an area where, again, I mean, Guatemala has a very strong argument, because, you know, when we look at the context of the use of the word constitution of the tribunal, we can look at Article 42 and what it requires for the members to have from Article 14, which is independent judgment. If we are going to believe that the tribunal member need only be independent at the beginning, once the papers are shuffled for that person to become a member of a tribunal, I mean, that really doesn't fit with the obligations imposed by Article 14, because it would mean that arbitrators could lose their independence and continue to serve, just so long as no one found out. Another thing that is really important is Rule 6.2. This is something that is really avoided by TECO. TECO wants to look at other things besides the text of Rule 6.2. And Rule 6.2 imposes a, quote, continuing obligation to notify the Secretary General. If it's continuing, it can't just be at the beginning, right? It's something that goes throughout the life of the tribunal's work. The context was not an issue in Azurix. And OIEG, strangely enough, never looks at Rule 6.2. It looks at different parts of the convention, but it doesn't get into Rule 6.2. And that's really helps to demonstrate part of the weakness with OIEG. Next slide, 13. Let's turn to the object and purpose of Article 52 1A. It has its own specific object and purpose. And really the committee in ICSID, we think said it really well. And you're going to see other references to this kind of language. And that is that there is no greater threat to the legitimacy and integrity of the proceedings or of the award than the lack of impartiality or independence of one or more of the arbitrators. In many ways, Article 52 1A is one of the greatest protections that you see here described by the ICSID committee. And to strip it down to what just happens at the beginning of a case really doesn't speak to its reason for existence. Slide 14. So on the object and purpose, what TECO is trying to do is it's trying to sort of deviate the interpretation and look at revision. So to limit Article 52 1A to something very, very small, perhaps almost something incapable of having any object and purpose at all, and instead point to revision. So let's talk a bit about revision. If we're talking about the object and purpose of revision, this is something that OIEG never gets into. That is also true of the footnotes that are cited, or the sites contained in the footnotes that you see referenced there. And this is also something that even TCC didn't advocate for in its counter memorial on annulment. Next slide. Let's look at the ordinary meaning of the text and how we see revision play out in the rules and in the convention. If you look at the rules, this is what an applicant has to do. The applicant has to identify the change sought. If you discover facts about an arbitrator, kind of difficult to identify the change sought within the award, right? Because it's not something specific in the award, it's the entirety of it. The applicant would never know what change to identify within the award. Second, the applicant can never state the fact that was unknown to the tribunal, because there's always going to be a member of the tribunal that knows the facts. And so the applicant will fail on this ground. And so that really doesn't make sense, the interpretation of TECO in light of these rules. Next slide, please. You'll see on slide 16 a little bit more about the context of revision. And really here, revision is something that ICSID speaks to, but makes a lot of sense. Revision is going to facts that underlie the tribunal's findings, right? If you look at requests for revision, they say, we want to revise X finding, Y finding, based on the new fact. Annulment is different. It's looking at the procedure that was followed and those fundamental rules of procedure, is looking at that constitution of the tribunal. And so that's why these facts that we have here in front of us are best in annulment, because they really have a totally different context. Next slide, please. Slide 17. Finally, let's look a little bit about how revision works in the context of post-award remedies. Both in Article 52 and Article 51, they use the verb may, right? What a party may do, not what it must. In many cases, there are simultaneous revision and annulment proceedings. So it seems kind of strange that if annulment is an exclusive remedy, it can exist only there, and we can't have any annulment at all. But it doesn't really make sense with these simultaneous proceedings, including in proceedings where we are working with White and Case, right? In the TCC case, where White and Case works on revision, and we work on annulment. This is something that wasn't addressed by OIEG. And again, OIG talks about it a little bit, but what it doesn't talk about is it doesn't talk about the simultaneous nature of these different proceedings and what we have seen develop over time. Slide 18, please. A little bit more about revision and just kind of what is really being proposed by TECO that Guatemala should have done. Revision. In revision, the members of the initial tribunal are invited to participate. They're not required to. So if any composition in that tribunal changed, then it would defeat the purpose that TECO argues, which is to have those people look at the facts again. And this happens. Sometimes a tribunal member passes away. Sometimes maybe a tribunal member develops a conflict of interest because they moved on. Right? They thought the case was done and they moved on. And so to require something to go to a different composition of that tribunal really is rather unworkable and doesn't make a lot of sense. And also it would make proceedings longer, right? Because then we would have revision and we might have annulment too. And so it really defeats this notion that we need to move things along. Next slide. Slide 19. So now we're going to turn to Article 52(1)(d). And again, this is an independent ground. So if there shouldn't be any sort of disquiet regarding 52(1)(a), but if there is, 52(1)(d). And here there are fewer slides, not because it's less important, because the parties, I think, are a lot closer in how they interpret it, and the distinction doesn't take as long for us to get through. So the parties really aren't disputing that there is a fundamental rule of procedure includes a right to be heard before an independent and impartial tribunal. or that the parties have a right of defense or fair trial. Those are pretty well defined. And we're not talking so much about what a serious departure would be. We don't have to have certainty. Also, there doesn't seem to be much dispute that unanimity alone isn't going to mitigate the lack of disclosure, because we don't know what actually happened within that tribunal. So let's go to where the parties are at odds on slide 20. And really, when you boil TECO's argument down, it's this paragraph. TECO argues that we should look at Article 52.1a and apply that analysis equally to Article 52.1d. To us, that really doesn't fit with the text. I mean, the articles have different texts, right? You can't just apply the analysis of one equally to the other when the words are so different. And so let's go to the next slide. Slide 21. Where does this leave us? Well, now we're going to move on from our analysis of the convention and the grounds of annulment, and we're going to get into, first, the failure to disclose, and then second, what that means. Slide 22. Disclosure. So a disclosure, there's a lot of helpful stuff on disclosure. First, the text, it's broad, it's continuing, and it's defined by any party's view. We don't have to go a lot of places to understand this because it's contained in the text of Rule 6.2. Also, we have the word circumstance, any other circumstance. Any is a very broad word. Circumstance is also quite broad. And this continuing obligation to disclose any circumstance. Again, the broadness, the continuing nature of it, it is something that lasts throughout the life of the tribunal. Next slide, slide 23. This rule isn't something that is somehow unique to ICSID practice. We have here the IBA Rules of Ethics for International Arbitrators, 1987. It's been around for a while. Recommends disclosure, quote, of any past or present business relationship, whether direct or indirect, with any person known to be a potentially important witness. That fits our case really well. Right? So TECO has relied on these rules in the past. It doesn't want to anymore. I understand. If I were them, I would say something similar. But the reasons aren't too convincing. The limitations on these rules for national arbitrators, they really look at court proceedings to vacate awards. Of course, the vacatur is a court concept, which makes sense because courts have their own rules. And second, TECO would have to identify, if it didn't want these rules to apply anymore, the conflict between this recommendation you see here and anything in the 2014 IBA guidelines on conflicts of interest. No conflict is identified between those two texts.
Sorry, Counsel, where did TECO rely on these rules before?
Oh, in the challenge to Professor Oriamuno.
In Oriamuno's.
Yeah,
okay,
I'm sorry.
Thank you.
I meant to say that. Thank you.
Counsel, can I just mention
Yes, sir.
that as a member of the IBA committee that drafted the guidelines,
Yes, I know.
it was assumed that those guidelines would supersede the rules of ethics.
Okay. Well, thank you so much, sir. I guess that brings us to our next point, and that is that if it was to be assumed by the members of that committee, TECO has relied on it itself here in this case. And the fact that TECO has relied on it, which led to Professor Oriamuno resigning, it has benefited from that reliance. And benefiting from that reliance is something that all of us know as judicial estoppel. So 2006, ICSID amends Rule 6 to add the text that you saw. Next slide, please. Slide 24. And then in 2011, this goes back to the challenge to Professor Oriamuno that we mentioned. This is what TECO had argued, that, quote, now we're moving to the standard of disclosure, does not depend on what information is known by the parties. Even publicly available information must be disclosed, if it falls in the category of information regarding disclosure. I'm not going to bring up the point of the conflict because Professor Jones has already helped us out on that. But again, I mean, this is an issue where TECO has relied on something and cannot now deny it. The last thing we're going to point out is 2020, when TECO's counsel, Ms. Lamb, or perhaps all she did was sign the notice of arbitration, but still widely known, successful, talented. She argued, quote, that Google is not enough, unquote. She further described arbitrators as, quote, guardians of the system. These are certainly words that Guatemala would adopt. The main response from TECO is that this only applied to commercial arbitration. I guess that's due to the title of the annual lecture, not the title of the speech, or the title of the annual lecture. Ms. Lamb, in that lecture, you can see it, she cited the 3 ICSID cases. So if it was only commercial, kind of funny that she only cites, or that she cites largely to ICSID cases. And in our practice, we routinely refer to bodies that might have the word commercial in them: UNCITRAL, T, trade. UNCITRAL does lots of commercial work. Just the fact that commercial work might be done doesn't mean that it only applies to commercial arbitrations. Next slide, slide 25. Now, all of these things that that we discussed, we can also see what Dr. Lexendrov thought about them. And this is what's really helpful about Rule 6.2, because he co-authored the decision in Alpha Project Holding. So this is 2010. And so we can be a little bit better informed about what he thought was proper disclosure. He interpreted Rule 6.2b broadly. He viewed the IBA guidelines as helpful to provide meaning to Rule 6.2b, and included those words, the view of the parties. Right. So on that, we're on the same page with Dr. Lexendrov. He also, quote, paid heed to respondents' point that in a given case, the very failure to disclose relevant and material circumstances might evidence partiality, regardless of whether actual bias is established. Again, we agree, right? Dr. Lexendrov did not recognize his continuing duty to investigate the facts underlying a challenge throughout the life of the case. So here it appears that Dr. Lexendrov was quite on the side of Guatemala. What else do we know about Dr. Lexendrov? He's faced a lot of challenges. His lack of disclosures or his issues that he's had on tribunals have led to challenges by Latvia, Argentina, Ukraine.
Sorry, can you go to the previous slide?
Yes, ma'am. Slide 25.
So exactly what did Alexandrov, as co-authoring the decision on the challenge, recognize as to the last bullet point? Did he not recognize a continuing duty of the party, or did he recognize that there was no continuing duty?
You know what? That is not well drafted. I will tell you right now. What he is saying in that challenge is that the party making the challenge doesn't have to be continuously, researching the arbitrator.
So he addresses the point, or the decision addresses that point directly.
Correct.
Okay.
And I mean, just to be clear, the decision wasn't necessarily made on that point. We're looking at the legal standard that was applied to, from there, try to glean what was in his mind, because that is important to us. So 2 challenges from Spain, a challenge from Saudi Arabia, Croatia, Nigeria, and Panama. This involves the country from every
Excuse
continent.
me, may I just ask, because I know that this doesn't have any citations.
Yes.
So are these all on the record, for instance, Saudi Arabia?
I'm just speaking about cases that are publicly available.
Well, you're speaking about them publicly available, but the rules were that we should have citations to the evidence in the record when a slide was, for everything that it was on a slide.
I'm just referencing it for the existence of the case, not for the content of the decisions, just the fact that there was a challenge. If this is a problem, the tribunal or the members of the committee are certainly well aware.
Well, you're saying the existence of the case, it doesn't even contain the case name. So we don't know what the existence of the case was.
Madam Chair, I mean, we're in your hands. What you want us to do with this. But
is this in the record? I don't know. It seems interesting to know in how many challenges Alexandrov has been involved. Is this part of is it somewhere in the memorial?
So most of these cases are. I think the reference to the Saudi Arabia one isn't. And Nigeria is very recent.
Again, Madam Chair, we object. He's stating it as a fact. We were very clear about this at the pre-hearing conference and before, that references, and that's why the references and citations need to be on the slides.
Okay. If it's a problem, let's just, we can strike the reference to Saudi Arabia and Nigeria. And I think the rest are on there. We'll see it on the next slide.
Let's strike the whole bullet point. You check and then you come back to us. Okay. Just to be sure what's in the record and what's not.
Okay. Ms.
Menaka, is that
move on.
okay for you?
I mean, there are also,
We're going to
they're
move on.
talking, some of the bullet points about countless lawyers signed their names to these challenges,
Mhm.
9 law firms. Again, those are facts that I don't believe are on the record, and I can't see the citations to
those are.
check.
Well, those are on the record. We can get to that slide and we can go through those
Let's skip
specific
the
ones.
slide and
Yeah,
come back to it
that's what I'm
later once you have checked what's exactly in the record.
Sure, no worries.
Thank you.
So Dr. Alexandrov has a history of inconsistent disclosures. I spoke about this at the beginning and how Pakistan learned of its cases long after they had been disclosed to Spain. Next slide, please. Slide 28. Here we go. So here's the record sites. These are the different challenges that we have. So it's ICS versus Argentina. There's Panama, Pakistan, Croatia, Soles, ICER, this case. So we can count the lawyers on those, but those are all the words that are in the record or are referenced. So let's keep going. Yes, ma'am.
Is there another one? I think TECO referred to another one in the latest memorial.
Oh, might be.
That was Meissen versus
Meissen.
Ukraine.
Yes.
Meissen,
That's correct.
true.
Is this one here as well?
Oh, you know what? We didn't include Meissen, but that would cover Ukraine.
Because that one was published in April this year.
It was recent, yes.
Will you refer to that case at some point? Because-
In the slide that was objected to 2 slides ago, the word Ukraine is there, but we're not going to talk about it anymore. We're going to move on.
We'll talk about it.
You will talk about it.
We will.
Excellent. Sorry for the interruption.
No worries. So how does TECO respond to this? It really doesn't engage with the text of Rule 6.2. It looks at different cases. Those cases are also not analyzing the text of the rule. There's some academic writing that's cited, but we're not getting into the text of the rule, which is what should guide us. Also, when coupled with Dr. Alexandrov's knowledge and his own position. Next slide, please. So let's talk about the other defenses. There's primarily, there's 3. We've already mentioned a bit the challenge in 2011. So let's talk about the next 2. This is slide 30. It's about proprietary information supposed that would be publicly available and should have been known by Guatemala. And that Guatemala's lawyers, their potential knowledge would be enough. We're going to take those each in turn. So slide 31. The proprietary knowledge. So there's no argument that TECO had actual knowledge. This is an argument on constructive knowledge. And so if we just look at the documents that were presented, you can look at them yourself. There is no mention of Dr. Alexandrov or Mr. Kaczmarek. So if we're going to go the constructive knowledge route, you wouldn't even see it in the text of the exhibits submitted. On these other 2 exhibits that we have here, you have to have a premium GAR submission or subscription to have access to these articles. And they mention Dr. Alexandrov as counsel, but there's no mention of Mr. Kaczmarek or Navigant. So if this is the constructive knowledge argument, there's really not much there. Citing to GAR in the past, maybe that meant Freshfield had access. But it's not like we can go through every citation in the record and assume that Guatemala has all those books and all those articles itself, right? That's not how it works. Council has access to different databases and it can make its presentation of what it finds in those databases. You can't impute that to Guatemala. Next page. Next slide. Slide 32. How about the thoughts of Guatemala's lawyers? So there's no real legal test offered by TECO, just some sort of presumptions. But, going to presume what a lawyer